Hi, welcome to this video on the use of the Welsh language in civil proceedings for SQE dispute resolution. This might seem a surprising topic to be tested on the SQE, but if you take a look at the SRA's SQE syllabus, you'll see that there is a bullet point under dispute resolution, which is labelled Practice Direction, Preliminary Considerations for the Use of the Welsh Language in Civil Proceedings. So it is important to understand the rules that I'll be going through in this video. I'll be focusing on what I think are the main rules on the use of the Welsh language, as set out in the practice direction on the use of the Welsh language, which I'll link in the description. It's a good idea to have a read of this fully after the video, so you can consolidate your knowledge on what I go over. And if you'd like to learn more about other points that I don't cover in this video and what I personally think are less important and less likely to be tested. The practice direction is quite short, so it shouldn't take you a long time to read through. Let's begin by looking at civil claim taking place in Wales. An example would be a civil claim taking place in a county court in Cardiff. Those proceedings are taking place in Wales. The first rule you should know is that the court must be informed by either the parties or their legal representatives where it is possible that the Welsh language might be used by a party or a witness, or in any document which might be placed before the court. Notice that this rule states where it is possible that the Welsh language might be used, and whether that's by a party, witness, or in a document, which means that the court needs to be informed, even if there's just a chance that a party, for example, might use the Welsh language in the proceedings. The second rule that you should know is that the court needs to be informed of when a document is going to be or may be placed before it in the Welsh language as soon as practicable. This rule does overlap with the previous rule, since the previous rule also required that the court is informed of a document potentially being placed before it in Welsh. But this rule adds the additional requirement that the court be informed as soon as practicable. This as soon as practicable requirement is not stated in respect of the notification requirement if a party or a witness want to speak Welsh in proceedings at some point, but it does apply if a document will or may be placed before the court in Welsh. The third rule you should know is that a hearing in Wales can be carried out fully in the Welsh language on an ad hoc basis, as long as all the parties and witnesses involved in that hearing agree to this. So you wouldn't just have one section of that hearing taking place in Welsh, everyone would be speaking in Welsh. The fourth rule that you should know is that the parties may need to inform the court on multiple occasions about the potential use of Welsh. This must be done in direction questionnaires, pre-trial checklists, and interlocutory hearings. Depending on what stage you're at in your studies, you might not know what these terms mean, so I'll briefly explain. A directions questionnaire is essentially a questionnaire sent to the parties to a claim to help the court gather information to decide what track a claim should be allocated to. A pre-trial checklist is essentially a checklist that parties may need to complete before a trial, and that enables the court to check that the parties have complied with maybe previous directions that the court has issued to the parties, and also to check that they're ready for trial. Interlocutory hearings are hearings taking place in the lead up to the determination of a case, such as hearings addressing interim or procedural matters before the main hearing. We just looked at using Welsh in cases taking place in Wales, but we also need to consider the rules on cases taking place in England but which have a connection with Wales. An example could be proceedings taking place in the London County Court, but which are connected with Wales in some way. This might be because one of the claimants is based in Wales, and Wales is also the location of whatever gave rise to the claim. For these proceedings, which are taking place in England but with a connection to Wales, the relevant rules that apply are the second and the fourth rules that I previously discussed. So, as a reminder, the second rule was that the court needs to be informed of a document that will or may be placed before it in Welsh as soon as practicable. This confirms that you can use a document in Welsh in legal proceedings in England, where the proceedings have a connection with Wales. The fourth rule that I described previously was that the parties may need to inform the court on multiple occasions about the potential use of Welsh, which are in directions questionnaires, pre-trial checklists, and interlocutory hearings. Those are what I think are the most important rules on the use of the Welsh language as set out in the practice direction on the use of Welsh. But what are the consequences if a party fails to comply with these rules? Well, the practice direction makes clear that if costs are incurred because a party has failed to comply with the practice direction, then a cost order could be made against that party or their legal representative. So that highlights the importance of complying with this practice direction. As I mentioned at the start of the video, it's a good idea to have a read of the practice direction if you can, which I've linked below. I hope you found this video useful. Please consider liking and subscribing, as that really helps the channel, and consider sharing this video with others that you know who are preparing for the exam as well. Until the next video, best of luck with your preparations.